Welcome, everyone, to Washington Legal Foundation's media briefing on the U.S. Supreme Court term. My name is Glenn Lammi. I am Executive Director and Vice President of Legal Studies here at the Foundation. For those of you not familiar with us, we are in our 46th year of free enterprise advocacy and education. If you want to know more about us, please spend some time on our website, wlf.org. We're pleased to have with us today a good panel of experts. So let me get started with proceedings. So the court this term has accepted 22 cases for review and has scheduled 13 of those cases for oral argument in October and November so far. Washington Legal Foundation's filed briefs in 3 of the granted cases, and we're planning to file in a 4th. This term begins with the court encountering a great deal of public and political scrutiny, attention which is only likely to intensify given the high stakes nature of several granted cases and because the term coincides with the federal primary season. Quite a few of those high-stakes cases, surprisingly, fall in the realm of WLF's missions, so you'll hear our panelists' thoughts on those today. I'll let you know that the program is being recorded, and if you have questions during the program, please use the Q&A function in the toolbar at the bottom of the Zoom webinar template. Introduce our speakers first. Tom Hungar is a partner in the Washington, D.C. office of Gibson, Dunn, and Crutcher. During his time at the firm, and while acting as assistant to the Solicitor General of the United States, Tom has presented oral argument before the Supreme Court in 27 cases. He has served as general counsel to the U.S. House of Representatives from July 2016 to January 2019, when he rejoined the firm. Tom has also served as a law clerk to Justice Anthony M. Kennedy and to Ninth Circuit Judge Alex Kaczynski. John Masslon is WLF's senior litigation counsel. He joined WLF in 2020 after having served as Assistant Solicitor General for the state of West Virginia, where he regularly practiced before both state and federal appellate courts. He also clerked for judges on the U.S. District Court for the Western District of Pennsylvania and on the Superior Court of Pennsylvania. And joining us, hopefully eventually, is Taylor Meehan, who's a partner with Consovoy McCarthy. She represents clients in all 3 phases of litigation, with a focus on constitutional litigation and appellate matters. Prior to joining the firm, Taylor was a partner at another national law firm and served as a law clerk for U.S. Supreme Court Justices Antonin Scalia, Clarence Thomas, as well as for 11th Circuit Judge William H. Pryor. So we'll have our panelists start off with a brief statement, and then we'll get into questions. Tom, if you could get us started.
Thanks very much, Glenn, and thank you to Washington Legal Foundation for inviting me to participate in this panel. And also for filing an excellent amicus brief in our support in the Murray against UBS retaliation case that's going to be argued next month in the court, given that we are representing UBS, and we'll be speaking about that case. But it's an interesting and important one. As Glenn mentioned, 22 cases only so far this term, so it's a little early to try and determine what the theme, if you will, of the term is going to be. And I'm not a big believer in themes anyway, since in my view the court's docket tends to be developed primarily due to random chance and happenstance and fortuity rather than any sort of intentions. Certainly, for instance, the Chief Justice's intentions, I can imagine, are to avoid any highly controversial hot button cases, but that hasn't worked too well in past terms, and we will see whether it works very well this term. If there is a theme so far in the cases that one could glean, I guess I would say it's whether Congress should be required to do its job, or instead whether the courts and or the executive branch will be allowed to do Congress's job for it. And a number of the cases that we'll be talking about today, I think, are illustrative of that principle. The Loper-Bright case, obviously, about whether and to what extent courts should defer to agency interpretations of ambiguous statutes. The CFPB case, which is asked the question whether Congress can abdicate its appropriations authority to an agency. The case that I said I can't mention, I think, could be placed in that category. And perhaps you could also, one of the first cases to be argued in the term pulsifer, at least according to the petitioner, presents the question whether when Congress says and, a court can say it means or instead, which you could perhaps put in that category. So with that, I will turn it over to John for his no doubt more erudite thoughts.
Thanks very much, Tom. John?
Thank you, Glenn. As we're here to discuss the court's business docket, I think it's key to understand the current business climate at the Supreme Court. If you read the media, you would think that this is a very business-friendly court, but nothing could be further from the truth. This is a court that has turned decidedly anti-business in recent terms. The first indication that the court is no longer business-friendly is the dearth of business cases that the court has agreed to hear in recent terms. More and more, the court is denying review on critical issues on which the lower courts disagree or in which no split is possible. Rather, the court is taking up insignificant cases. The reason may be that the court is looking at the business docket as a way to build consensus in decisions, to help counterbalance the more controversial cases that, as Tom mentioned, the court has been unable to avoid in recent terms. And the issues on which there is a split generally don't lend themselves to unanimous decisions. When it does agree to hear business cases, the court has started to rule against business interests more often than it rules for business interests. For example, last term's super value case made it easier to sue businesses under the False Claims Act. In National Pork Producers Council, the court made it easier for states to regulate conduct outside their states, which makes doing business across state lines even more difficult. And Mallory was the most important and disappointing business decision from last term. It allows states to exercise personal jurisdiction over companies just because they registered to do business in that jurisdiction. These cases follow on the heels of Morgan and Sundance, two arbitration cases that also went against business interests. Again, I think much of this has to do with the Chief Justice, Justice Kavanaugh, and Justice Barrett wanting to be seen as moderate. One way to do that is to rule against business interests to balance conservative rulings on hot-button issues. We'll see whether that continues again this term. Looking ahead, I think there are two things to keep an eye out at oral argument. The first is whether Justice Jackson continues to dominate arguments the way she did her first term. She took up a ton of time at most of the oral arguments, and that is one reason that arguments last term were so long. The other thing to keep an eye on is who is arguing at the court this term. There are going to be many first-time advocates and many inexperienced appellate advocates at the court. This has become rarer and rarer at the court, and for good reason. Last year in In Re Grand Jury, we saw a dig after oral argument because of how oral argument went. It'll be interesting to see whether with more inexperienced advocates at the court this year, we'll see more of that dismissing as improvidently granted cases because of how the oral argument went. I think this is setting up to be a very interesting term, and we shall see how the court goes both on the business docket and in the more controversial cases.
Thanks, John and Tom. So we'll start off by talking about one of the focuses that I think has emerged for this term is the design and structure of the administrative state. So on the very second day of the term, the court's going to assess the legality of the Consumer Financial Protection Bureau's unusual funding mechanism. John, do you think the agency's future at stake here?
No, I don't think so. Even if the court finds, as we argued in our amicus brief, that the funding structure violates the appropriations clause, the court will almost certainly find that the funding mechanism is severable from the statute creating the agency itself, and will just require the agency to go back to Congress every year to seek an appropriation of funds, rather than just tell the Federal Reserve give us this much money, and then receiving that funding.
Tom, some of your colleagues at Gibson Dunn authored a brief for former members of Congress. How do you think a decision for the respondent might impact congressional decision making on funding of agencies, kind of more generally?
Well, I'd say, so first of all, that brief argues that that essentially by giving the CFPB a blank check, it amounts to an unconstitutional abdication of congressional responsibility for governing the appropriation process, actually deciding what money can be spent by what agencies for what. I think that if the court were to agree with the Court of Appeals and strike down the funding mechanism, it depends a little bit on the rationale. My expectation is that the court would say, in essence, what the petitioners and the amicus brief that my firm filed say, which is that this particular agency, which has vast powers, which is using these unappropriated funds not merely as sort of a cost covering mechanism where, so there are many agencies, the National Park Service, the Post Office, the Patent and Trademark Office, that charge fees for some of the services they provide, and they use those fees to pay for the services. If you get a passport from the State Department, you pay a fee, then the State Department funds its passport office using those fees. And those are all non-appropriated funds. Some entities are entirely funded by non-appropriated funds called non-appropriated fund entities, like the military exchanges, stores on military bases and the like. If a sweeping rationale would invalidate all of those agencies and funds and require Congress to appropriate all that money, which would have a very significant impact. But the parties argue that those aren't really at stake because the CFPB, unlike those agencies, is not just a fee-for-service agency. It's taking money out of an unrelated fund that itself is unappropriated, the Fed, and using that sort of double lack of congressional oversight to spend on its massive regulatory authority in a way that is completely unprecedented in the history of the country. And if you can do that with an agency with such sweeping regulatory authority like the CFPB, then you could essentially eviscerate the appropriations clause entirely. And that rationale, if that's what the court says, would really not affect any other agency. It would tell Congress not to do this again, and that's about it.
So the question also in that case is what should be the remedy? John, it sounds like you think that there's probably going to be a severability issue there with the remedy. Can you elaborate a little bit on that?
Well, theoretically, the court could hold that the funding mechanism, like Congress wouldn't have created this agency without this independent funding mechanism. And so therefore, the entire statute creating the agency must fall. I just don't see the court going that way. I think if the court were to find that the funding mechanism violates the appropriations clause, the much more likely scenario is the court to say that portion of the statute is severable, and therefore what the agency must do is go to Congress every year and seek an appropriation like most other agencies.
One of the other cases that's going to involve the structure of the administrative state, probably the one with the highest stakes, is SEC versus Jarkesi. John, can you tell us a little bit about that case?
Sure. It's an SEC enforcement action where gentleman Jarkesi and his and a company he worked for and kind of founded, they got charged in an administrative proceeding with violating the Exchange Act, the Securities Act, and the Advisors Act. The case went to an ALJ. The ALJ issued a recommended decision finding that he violated those statutes. It then went to the full commission, who again adopted the ALJ's recommended decision. It imposed a six-figure monetary penalty against the respondents. It also barred Jarkesi from operating in the securities industry for years to come. He challenged that in a petition to the Fifth Circuit. after you lose before the full SEC, you don't take your appeal was via petition to a court of appeals. He decided to petition the Fifth Circuit. The Fifth Circuit held that the proceedings below violated the Constitution for 3 reasons. The first is that the SEC, just like the FTC, has the ability to file a complaint either in its own administrative courts or in district court. And the Fifth Circuit said that choice violates the non-delegation doctrine. Second, the court held that it violated the Constitution for the ALJs to be able, there's 2 levels of for-cause removal protection for the ALJs. And then finally, it said that it violates the 7th Amendment right to a jury trial to allow the SEC to adjudicate these private rights.
So there's a number of issues that the court could rule on with regards to the Cherkasy case. What's the likelihood, John, that they're going to get to all of them? Is there one in particular that you think that they might be able to rally a majority around?
I think there are a couple issues they could rally a majority around, but I do think it's likely that they reach all 3 issues. I'd be kind of surprised if they didn't. If they're going to rule for the SEC, they're going to have to reach all 3 of the issues because each ground is independently enough to throw out the SEC's decision. So if it wants to reverse, it's going to have to reach all 3 or even vacate. Now, if it wants to affirm, it could theoretically rule on just one of those issues. I think the most likely for it to rule in favor of Cherkasy is the ALJ removal protections. I think that if the court wanted to, it could say that in cases where there are monetary penalties like this, that the ALJs can't enjoy 2 levels of for-cause removal protection, and therefore affirm on that basis and just decline to reach the non-delegation and the jury trial issues. I don't think that's likely because I think the court wants to address those 2 issues. And so there are ways for the court to address all 3 issues, even if it's going to affirm only on the ALJ issue.
Tom, there's been some discussion on the court in other cases through separate opinions by certain justices on the non-delegation doctrine. It was a very sweeping part of the opinion in the Fifth Circuit's opinion on the non-delegation doctrine. Who do you think is going to be most interested in focusing on that in their opinion?
Well, so as you were suggesting, the court a few years ago in the Gundy case had a big dust up over the non-delegation doctrine and whether the traditional standard for assessing the validity of a congressional delegation of legislative authority, which basically asks whether Congress has specified an intelligible principle for the agency to apply in exercising the delegated authority, whether that intelligible principle standard needs to be beefed up or not. And the court, in an odd lineup, basically split 4-4, although Justice Alito joined the majority in order for there to be a decision, but said in an appropriate case, if I've got 4 votes, I'm willing to add some teeth to the doctrine. And since that time, Justices Kavanaugh and Barrett have joined the court. So it would not surprise me if there is a majority willing at least to seriously consider adding teeth to the doctrine, and saying that intelligible principle doesn't just mean Congress says a few vague words and then the agency can do what it wants. I doubt that this case is the case that is going to allow the court to say that, though, because there are 2 problems here. One, if this is a congressional delegation of legislative authority, there is no intelligible principle by any way, shape, or form, because the alleged legislative delegation is is simply the authority of the commission to choose whether to bring an action in front of its own ALJ or instead go to court. And there's not even an argument that I can see that Congress provided some intelligible principle that the commission is bound to apply in making that decision. The real question, therefore, in this case, unlike the more traditional delegation, non-delegation cases, is this a delegation at all? Is this a delegation of legislative authority? And there, I think the Fifth Circuit decision is susceptible to challenge because they say that, well, the question whether to bring a proceeding to impose civil penalties in front of an agency or in a court is a legislative question. And certainly it's true that the authority to create one or both of those mechanisms is a legislative authority. An agency couldn't just make that up on its own without legislative authority. But here the problem is Congress itself created those two mechanisms and said to the SEC, you can use one or the other. So the administrative mechanism is authorized by legislation. And the mere choice of which procedure to use, it certainly is susceptible of the argument that it's more of an executive than a legislative function. And if that's true, then there's no delegation and you don't even get to the intelligible principle test.
John, last term, the court decided to allow a constitutional challenge against the SEC, the FTC's structure to go forward in the Axon case. Is there a possibility that a decision in the Jarkessi case will have an impact on how that decision plays out in the lower courts?
Yes, I mean, I think that especially on the ALJ removal issue, that if the court were to affirm on that basis, you would see, for example, the Axon decision probably get thrown out, or there's no final decision in Axon, but you would see a decision by the District of Arizona that says that, the FTC cannot proceed in front of an FTC ALJ that enjoys 2 levels of for-cause removal. Now, on the choosing to go to the non-delegation issue, I mean, I guess, again, it's theoretically possible that could affect Axon, but I kind of doubt it. And I don't see how the, Seventh Amendment issue really would play out in Axon, because I don't remember a Seventh Amendment issue being raised there.
So while we're still on the issue of federal agencies and judicial scrutiny, it's impossible not to talk about the Loper Bright case, which is getting probably more attention than any administrative law case in the history of the Supreme Court, at least in my time in practice. Like each of your thoughts on that, and I guess we'll start with Tom. Do you think we'll get a full loaf reversal of Chevron here, or a half loaf that's more focused narrowly on the issue of regulatory silence?
I don't think we'll get a full loaf reversal in the sense of the court holding that Chevron is overruled. I think it's possible that we will get a substantial cutting back on Chevron, although it's also quite possible that a much narrower decision will ensue. And just by way of background, of course, the question in this case is about the legality of a Commerce Department regulation that requires herring fishermen, among others, to pay for monitors on their boats that make sure they're following the rules about herring fishing, which I'm sure are many and complex. Under a statute, the Magnuson-Stevens Fishery Conservation and Management Act, that doesn't say anything about the Commerce Department having the power to require herring fishermen to pay for the cost of these monitors. It just says that the fishermen have to allow monitors to go on their boats. And moreover, the statute does say in several other provisions that the Commerce Department does have the power to require the regulated entities to pay for the costs of the regulatory activities. But this particular provision does not include such a mechanism. The DC Circuit nonetheless held that because the statute was quote unquote silent as to the question whether the Commerce Department could require the industry to pay the cost of the regulation in this particular circumstance, that meant this was a delegation of rulemaking authority to the agency to decide what it wanted to do over a very strong dissent, which pointed out that Congress, having specifically addressed the question of when the Commerce Department can require the industry to pay fees, and not having provided that authority here, that seems like it pretty much answers the question. And the cert petition presented both that question, the sort of the standard Chevron question, is this foreclosed by the plain language of the statute, as well as the question whether Chevron should be overruled. The court only granted the second question, so that not the threshold question. So that suggests the court, at least 4 justices, are very interested in cutting back on Chevron, and we already knew that anyway from a lot of decisions that many justices have been commenting one way or the other on what they think ought to be done with Chevron, what they think is problematic about it. So sorry, this is a very long-winded way of getting to your question, Glenn. And I think Chevron itself, in terms of the actual holding of the decision, which involved an exercise of deference to an agency's exercise of policy discretion, basically in a statute where the question is not clearly answered by the statute, but it's clear that the agency has to answer the question in order to regulate. It's basically the definition of how you count the source of emissions for determining what the emissions limit is under the Clean Air Act. The court said, and the challenge was that basically the agency had made a bad choice as a policy matter, and the Supreme Court said, well, yes, of course we have to defer to the agency's expertise in making a policy decision about how best to implement this discretion that the Congress has undoubtedly conferred on it. So that in that context, I can't imagine the court is going to say, oh no, we overrule Chevron in that respect. But of course, the broader question for which Chevron has been understood to stand is basically, if there's an ambiguity or a gap in the statute, does that mean the agency has delegated authority to legislate, essentially through rulemaking, and resolve the ambiguity, full stop? And on that question, I think, several justices have indicated that they think the answer to that question ought to be no. Chief Justice Roberts has suggested he would like at least a much narrower restriction on the scope of Chevron deference. And then you again come down to Justices Barrett and Kavanaugh, where it's a little hard to know. Although I think Justice Kavanaugh at least has signaled, he joined a dissent by Justice Gorsuch in the Kaiser case a couple of years ago about our deference to agency interpretations of their own regulations, which, although it wasn't addressing the broader Chevron question, if you believe the language of Justice Gorsuch's dissent that Justice Kavanaugh signed on to, it seems to follow that Chevron ought to be on its way out in terms of the broader deference to whenever there's an ambiguity or silence in a statute. So the short answer with the long windup is I don't think Chevron will be overruled. I think there is a significant possibility it will be meaningfully restricted in a way that takes away from agencies the ability to exercise essentially broad lawmaking powers whenever, as is increasingly common, Congress has not spoken clearly to the question.
Thank you, Tom. I was going to be tempted to ask Taylor, what would Scalia do in this situation? Unfortunately, Taylor had a very unexpected emergency situation with a client of hers, and she indicated she asked me to let everyone know that she's greatly regrets not being able to join us today, and it was just a very strange situation for her. But we thank her for her interest in doing it, obviously. But we plow forward. So, John, in the government's brief that was filed yesterday, they raised the specter of a shock to the system, basically, if Chevron is overruled. Is that anything more than sort of hyperbolic language by the SG's office?
No, I don't think it would be a large shock to the system for a few reasons. The first, as Tom said, I don't think that they will completely overrule Chevron. I think you're going to see a significant cutback in when agencies may use their authority to have this broad rulemaking authority. But even if the court were to completely overrule Chevron, we're not going to see a large sea change. At the Supreme Court, it almost never cites Chevron anymore. So you're not going to really see a change there. And the courts of appeal, even there, you're seeing less and less citations to Chevron. You're seeing more things decided at what's referred to as Chevron Step 0 or Step 1, where the lower courts are saying that, well, actually, there is no ambiguity here, and so therefore we're not going to defer to any agency interpretation. Sure, it may affect a few cases, particularly at the DC Circuit, who uses Chevron deference more than some of the other circuits. But I'd also look at some of the amicus briefs that have been filed in the court dealing with how this has operated in the states that have gotten rid of Chevron deference. So in the state, of course, state courts aren't required to use Chevron deference when construing state statutes or state administrative regulations. And a few state legislatures have recently repealed Chevron deference, or state Supreme Courts have said, we're not going to apply Chevron deference in this state moving forward. And we really haven't seen the upheaval in those states that the Solicitor General argues that we would see in the federal system if we get rid of Chevron. I think that shows that this is not going to be some kind of cataclysmic event by saying that, hey, Congress, you actually have to do what your job is, and hey, agencies, we haven't elected you, so therefore you're not allowed to make laws for the entire country. I think what you'd see is that the agencies would try at least to apply the law that Congress has written. You may see some more statutes passed by Congress, but if not, you'd see it just go down the states and have more state regulation of certain industries. But I don't think that it's going to be a big shock to the system if the court completely overrules Chevron.
Thank you, John. So another case that touches on the judiciary's constitutional role involves whether there's a case or controversy when a so-called litigation tester sues a business under the Americans with Disabilities Act that she has no intentions of patronizing. Tom, there seems to be several ways the court could go in finding no standing in Atchison Hotel versus Lawford. Do you think there's any chance that it will find standing?
I don't think so. Although it's maybe not as simple as it might at first seem. So just as a way of background, in this case, the Americans with Disabilities Act, of course, forbids discrimination against individuals based on disabilities. And circling back to the Chevron case for a moment, that confers on the Justice Department and other agencies rulemaking authority. And the Justice Department has promulgated regulations for hotels and places of accommodation that requires them in their internet advertising to specify various accessibility information so that disabled individuals can know this hotel has the following number of accessible rooms, and here's the nature of the accessibility options available, and so forth. And this tester goes around reading internet sites, determining whether they comply, in her view, with the regulations, and then if they don't, filing lawsuits, seeking injunctive relief and attorney's fees, even though she has no intention of ever visiting the hotel or place of accommodation at issue. And the Court of Appeals, there's a circuit split on this question. The Court of Appeals in this case said she has standing relying on a Supreme Court case from decades ago called Havens Realty, in which another tester, in this case, two testers actually, a black and a white applicant for an apartment, applied for an apartment at an apartment building, and the apartment complex told the black person, we don't have any vacancies, and told the white person, we do, which is a violation of an express provision of the Fair Housing Act, which says that it's racial discrimination, not surprisingly, to lie to someone about whether you have a vacancy based on their race, and provides a cause of action, a specific cause of action for violations of that provision. And this plaintiff, the black tester, sued and went all the way to the Supreme Court, which said, yes, they have standing because they have a statutory right. They not to be lied to on a racial basis, and a statutory cause of action to enforce that right, and they have standing. So the plaintiff in this case says, well, therefore I have standing as well. So in order for the court to rule that there's no standing, which I expect they will have to either overrule Havens Realty or at least limit it to its facts. But there are, I think, a number of ways for them to do that, including the fact that here there is actually no statutory right to this information that the tester, the ADA tester, was looking for. It's just a mandate that the information be provided on the website. Is not a personalized right not to be lied to or not to be given the information. And there's no statutory cause of action specifically for violations of that informational right, unlike in the Fair Housing Act. And in fact, the ADA doesn't even impose the obligation to provide the information. It's purely a matter of regulation. So those would be grounds for distinguishing it. But they would have to do that. And then in addition, the plaintiff argues that, well, there's a stigmatic harm because of the stigma of not being provided information, given that she herself is a disabled individual, and the failure to provide this information is somehow stigmatic, analogizing to the stigma felt by a person who's discriminated against on the basis of race. That not only is that, one would think, somewhat dubious, at the very least, it also ignores the fact that in this case, the only relief being sought is prospective injunctive relief, which of course would not remedy the retrospective harm. And to the extent there's any stigma, therefore, it's already been suffered, and the injunctive relief isn't going to stop that. And presumably there's no further stigma that could be suffered from the fact that the website continued not to provide this information, since she already knows that. And in any event, the website has been amended, has been revised to provide the information as you would expect. So the court will have to do some work to go through these arguments, but I think it's reasonably likely that they will. Although an interesting wrinkle about this case is that both parties are arguing that the case is moot. The defendant says it's moot because they've changed their website and only prospective relief is sought. The plaintiff says it's moot because she actually dismissed her complaint in the district court with prejudice, obviously in an attempt to avoid getting the Supreme Court to shut down her racket of bringing these kinds of cases against hundreds of small mom and pop motels and bed and breakfasts and the like that don't comply with the ADA on their websites. So it's conceivable that the court could avoid deciding the question, but I think having granted cert to decide the question of whether testers have standing, I think we can expect the court to decide that question. And even if they think the case is moot, standing and mootness are both justiciability questions, and there's no reason why the court can't decide the case on standing grounds as opposed to mootness grounds.
Thank you, Tom. The court issued some really interesting and nuanced statutory interpretation decisions last term. And our next case, Murray versus UBS, promises to be just as interesting. The whistleblower provision of the Sarbanes-Oxley Act and whether the statute requires proof of retaliatory intent are at issue. John, can you tell us a little bit about the Murray case?
Sure. So Murray worked for UBS, and UBS decided to downsize the unit he worked for. So he was an analyst. He was the only analyst that worked in this unit for UBS. And because of market changes, UBS decided that he was no longer needed, so they let him go. He then sued, arguing that the reason he was let go was because he had raised some concerns with UBS about some other issues. And so he sued under Sarbanes-Oxley, which allows employees of public companies to sue if they're let go because of any type of whistleblowing activity. the question that the court has agreed to consider here is who has the burden of proof? And it's a very interesting question under what's called AIA 21, which is a statute that set that the Sarbanes-Oxley Act incorporates the remedy provisions of that statute here. And so what Murray is arguing is that the employer has the burden of proof here, and that it's not the employee's burden to prove kind of the elements of a whistleblower claim. And the Second Circuit agreed with UBS that it was the employee's burden, and there's a circuit split on the issue, and so the court has agreed to decide this, and it will be an interesting decision, to say the least, about how the court interprets this, both the AIA 21 and Sarbanes-Oxley. You see in the brief by the petitioner and also by the government here, a lot of reference to the Whistleblower Protection Act, which is a statute that protects federal employees from being discharged because of whistleblower activities. And what they argue is that this Sarbanes-Oxley was kind of based off of the Whistleblower Protection Act, and therefore, because some lower courts, mainly the Federal Circuit, have held that the Whistleblower Protection Act places the burden on the government, that the Supreme Court should interpret Sarbanes-Oxley in the same way. What we explain in our brief is that the text of the statutes are different. So the text of Sarbanes-Oxley really doesn't resemble the text of the Whistleblower Protection Act, that the legislative history is very different. What Congress was attempting to do in the Whistleblower Protection Act was really upend the whole system for protection of federal workers, while in Sarbanes-Oxley, it wasn't trying to upend how all public companies hire and fire workers. And then finally, that just the way that private industry works is very different than how the federal government works. You know, it's almost impossible to fire a federal employee. We all know that. And while in private industry, companies decide to hire and fire individuals for many reasons. And to say that this burden rests on the employer versus the employee, it makes sense when the federal government, if an employee is almost never dismissed, then it kind of makes sense that the government has the burden to show that it wasn't a retaliatory intent. While under Sarbanes-Oxley, that wouldn't make sense because the companies hire and fire for many reasons. So it makes more sense under Sarbanes-Oxley to make the employee prove that there is retaliatory intent to prevail on a whistleblower claim. And that's what the whole case, again, revolves around, is who has this burden on retaliatory intent. Does the employee have to show retaliatory intent, or does the employer have to show a lack of retaliatory?
Thank you, John. Just want to remind everyone that if you do have any questions for our speakers, please ask the questions using the Q&A function in the webinar toolbar bottom. The last case that we'll talk about that's been granted is actually the last one that the court granted a few weeks ago, the Purdue Pharma case, which kind of caught some people by surprise. John, what was unusual about the court's granting in that case, and what might the decision's broader implications be?
So the case was granted not on a cert petition. Rather, there was an application to stay from the Solicitor General's office. And as is typically the case in these type of applications, the Solicitor General said, alternatively, the court could treat the application for stay as a petition for writ of certiorari and grant certiorari just based upon the application. The court took the SG up on that offer and granted the case despite, again, no cert petition, just on the application and treating the application as a cert petition. The case could have very broad implications moving forward in bankruptcy law. So just stepping back, this deals with Purdue Pharmaceuticals and the Sacklers. The Purdue Pharmaceutical bankruptcy is part of that bankruptcy proceeding. The bankruptcy court essentially barred further claims against the Sacklers in their individual capacity. The Second Circuit affirmed that decision, and the federal government and a large group of plaintiffs in these other cases against the Sacklers are saying that that violates their due process rights and exceeds the bankruptcy court's authority to bar these or discharge, however you want to phrase it, these claims against the Sacklers in their individual capacities. What's interesting is that this is more, we've seen this more and more where there's been companies are seeking to use the bankruptcy proceedings, or debtors in general and other individuals have been seeking to use the bankruptcy process to avoid other types of litigation, a lot of mass torts. We've seen it with Johnson & Johnson in the District of New Jersey. We've seen it with 3M down in the 11th Circuit. And what I think could happen here is we could see a broad ruling from the court about the proper uses of the bankruptcy code and of bankruptcy proceedings moving forward. And so although this may appear to be kind of a narrow case about whether these certain claims could be barred by the bankruptcy court, I think it could have broader implications for how bankruptcy courts operate.
Just an indication of how topical this is. There's, I believe, a hearing on the Hill today on this particular issue, the use of the bankruptcy system to deal with mass tort liabilities and trying to get money into the hands of plaintiffs before things like the asbestos process will allow you to. Before we move on to talk about the certiorari petitions, John or Tom, are there any other cases that we haven't focused on that you'd like to mention that our audience should be paying attention to?
Well, I'm happy to. I don't know that it fits too well into the business docket, although increasingly we're seeing First Amendment issues being extended into, at least in some respects, into the social media realm in ways that implicate private companies. But the social media, the two social media cases that the court has granted are very interesting to me, in part because of my time as general counsel at the House of Representatives, where we dealt surprisingly often with questions about what a member of Congress can or can't do with their social media account when they're being bombarded with incredibly hostile or obnoxious commenters. So these cases, Lindkey and O'Connor-Radcliffe, present the question whether a social media account of a government official, where the government official blocks people who comment in ways that the government official doesn't like, constitutes state action such that the First Amendment applies to that or not. Now, these accounts are personal accounts, but the officials use them for government-related purposes, talking about activities of their office and posting announcements and new initiatives and the like. But they treat them as personal accounts for purposes of blocking commenters. And the question is, and the courts are divided over the question whether the First Amendment applies in those circumstances, given the government-related activities of the public official, albeit using a private account. Then there are separate questions, which these cases are not going to address, about whether you have a quote-unquote official account on, say, Facebook or some other social media, Twitter, what have you, and how, if at all, the First Amendment applies to that. This issue that the court's going to be deciding, of course, came up most famously in connection with President Trump's Twitter account, where he blocked people who he didn't like their comments. And the Second Circuit said this was a violation of the First Amendment. And the Supreme Court then vacated that case. So we'll now find out the answer, but it could have interesting ramifications for the ability of government officials to manage their social media accounts.
Thanks, Tom. On the search side, there's going to be the long conference on September 26th. One of the cases that I believe is scheduled for consideration that day is one that WLF filed a brief in that implicates the multi-district litigation process. John, can you talk about that a little bit?
Sure. So that's the DuPont case. And what that deals with is something called non-mutual offensive collateral estoppel. So essentially here it's an MDL, and the courts, with the parties' input, selected a few cases for these bellwether trials. And then the bellwether trials, the juries ruled in favor of the plaintiffs on certain issues. And then what the court said is that in future trials, that the defendants couldn't relitigate those issues, that this was, collateral estoppel, whereby the jury's rulings in the bellwether trials apply for all future cases in the MDL. So essentially, the plaintiffs got to pick the worst of the worst cases, try those to a jury in a district that was favorable to the plaintiffs, and then say that that's binding on the defendants for all cases moving forward. Now, obviously, we believe that that's a violation of not only the rules, but also of the due process clause, and are hoping that the court agrees to review that issue.
There was quite a few other amicus briefs in that case, some from individual companies, which is a rarity. It just shows, I think, that how much of a concern there is in this area. Tom, do you have any sort of petitions that you'd like to highlight?
Sure. So we've actually just recently filed, not me personally, but my colleagues, a cert petition in this kind of crazy case out of the Ninth Circuit called City of Grants Pass against Johnson, which presents the, to me, somewhat startling question whether civil penalties for unlawful camping in city parks violate the cruel and unusual punishment clause. Civil penalties, not criminal, and they're a few $100s at most. And the Ninth Circuit has now twice said that a city has a constitutional obligation to provide housing for homeless people, or if it doesn't, then it can't evict them from city parks or wherever else they may be choosing to camp, which obviously has posed challenges for municipalities within the jurisdiction of the Ninth Circuit that are trying to deal with homelessness problems. Even though the Ninth Circuit is not the most conservative circuit in the country, the vote to take this decision en banc failed by one vote, 13-14. A total of 17 sitting active and senior Ninth Circuit judges joined one or more of the 5 dissents from denial of en banc rehearing. I'm told that there is going to be something like 35 amicus briefs filed in support of the cert petition from municipalities all across the West. So it'll be interesting to see what the court does with this. But it's an interesting, to say the least, an interesting extension of the Eighth Amendment.
Indeed. So the term, as I noted at the outset, is going to intersect with the 2024 national election cycle, a period where the court's undoubtedly going to be far more in the spotlight than the justices would prefer. How might that attention affect this term, and do you see the court getting dragged into matters that could directly or even indirectly impact the election? I'll have John answer that one first, and then Tom, provide your thoughts.
I mean, I think it's definitely going to affect the court's term. I think the first way you're going to see it affect the court's term is I think you'll see less cases granted than you otherwise would. The court is going to want to keep some bandwidth for the spring so that it can hear any type of emergency case that is brought that will affect the election. Of course, we've all read Will Bode's argument about why Section 3 of the 14th Amendment is self-executing and therefore bars former President Trump from running for office. And I think it's quite likely that one of those cases will reach the court in the spring. I think they're going to want to have some bandwidth to address that. I think you're also going to see some other cases, mainly dealing with how state courts can interpret state constitutions that are going to be brought to the court. We saw opinions, for example, from Justice Alito that said that, although these issues were raised after the 2020 election, they became moot, but that it's an important issue that needs to be decided. I think that if the court can decide it on its time frame, it's going to decide those types of questions. So I'd be pretty surprised if we see a full docket set for the spring, just so that the court can do that. And like I said, I think the court will see some of those cases. I also think that it's more likely that you're going to see Chief Justice Roberts try to pave a middle ground on some of the more controversial cases that are going to be issued in June, because he doesn't like the court to be in the spotlight. And if, for example, you see either whether it be the Second Amendment case the court has granted, the redistricting case that the court has granted, those types of issues, he's going to try to seek a middle ground versus a decision that is very conservative or very liberal.
Thank you. John, Tom?
Yeah, I generally agree. I don't know that the court's going to be trying to keep its docket down. They seem to have they seem to do that automatically, and if anything, I guess is they're concerned about the relative paucity of cases on the docket so far this year. And I mean, they no doubt they work hard and the work expands to fill the time. But I'm old, and when I was a law clerk, they decided 140 cases a year, and they seem to do just fine, or at least to the extent they didn't do just fine, it wasn't because of the workload. And so they could dramatically increase the number of cases they decide if they needed to, and they thought that the cases merited their attention, in my view. But I am confident that John is absolutely right that the Chief Justice is going to do everything he can to try to keep the court out of hot button cases to the extent they can be avoided, and to decide, to the extent they can't be avoided, to decide them in ways that are as close to unanimous and as narrow as possible. And I suspect there are many other justices who share versions of that preference. And yeah, I think John's also right that there are issues percolating that could reach the court, and I think would be, depending on how they come up, they could be unavoidable. So this spring and potentially over the summer even, and in the fall. The talk about the Purdue Pharma case and the stay application that had the footnote saying, please treat this as a cert petition, reminded me of the only time that I've been involved in filing a stay application like that, which was the Bush versus Gore case, where we filed our stay application Friday night. The court granted cert on Saturday afternoon, and the briefs were due Sunday afternoon, and the case was argued Monday and decided Tuesday. So we may see some of that.
Thank you very much, both of you, for joining us today and carrying a bit more of a load than we had originally asked you to do. We really appreciate that. Everybody that is on, we will continue to be involved with the court this term, both filing amicus briefs, doing publications, and in February, we always do a midterm briefing, which I think could be very interesting considering some of the earlier cases that we have on the docket, although I think as of our February briefing this year, they had decided one single case. So we may be talking more about what hasn't been granted yet then. So we will definitely keep in touch with those of you who are interested. And again, Tom, John, thank you for joining us today.